We are now set to embark on our final pathway related to inclusion, diversity, and multiculturalism as it applies to both employees and students. And I thought we might pause just a second before we jump into this pathway to talk about why some of the pathways we spend a little more time than others in Compliance 101. And the answer is actually quite simple, is that certain areas, there's quite a bit to know at the foundational and basic level, and stuff that frankly a lot of you may be using on a very regular basis. And some of the other pathways, you almost immediately jump into intermediate and advanced understanding, and so there isn't really that much of a toe in. Now, think of it like a beach that has really heavy surf. You'd have to be pretty good to go in the water, and it isn't really for beginners. Some of the other areas are beaches that we all go to with our families and enjoy, so that may give you some sense of why we're doing this. Something else occurred to me too as we were heading into the final pathway that many of you are probably thinking, well, I knew that. I knew that information. That's familiar to me. And that's a great sign. One of the things I assumed might occur as you went through Compliance 101 is that you'd recognize a lot of this information, but it might not have been clear to you just how foundational it was. And hopefully we filled in some gaps, things that you haven't heard before or seen organized quite in this way. Let's enter the interesting world of inclusion, diversity, and multiculturalism. Let's start with employees. A quick tour of basic employment law. We really see the emergence of individual employee rights since the Civil Rights era. Title VII of the Civil Rights Act is critical, and then you see a variety of other acts that have impacted employment rights in higher education. Again, many of these we've talked about in other contexts, and you will see come up in other areas, but notice an impact on race and sex discrimination, age discrimination, family leave, disabilities, etc. State law claims have also become very important, so it isn't just Congress that's jumped in the middle of employment law, but the states have as well. And we often see a variety of state law claims raised in employment, including breach of contract, but also these torts and wrongs, intentional infliction of distress, assault and battery, unfortunately, privacy issues, false imprisonment. There are folks that still corner people in their offices and don't let them leave, wrongful discharge, and defamation claims. The basics of employment law are not terribly difficult to sketch. It gets a little more complicated as we get into particularly some of the civil rights areas. And again, this will be perfect for intermediate and advanced learning. But we should all know about the at-will employment doctrine, which has had substantial influence throughout the United States. And at-will employees are typically subject to the possibility of termination without reason, notice, or cause. And so folks will sometimes, unfortunately, find themselves in a situation where they're packed out of their office and not given prior notice or even a rationale for why they're being let go. This doctrine is often applicable to large classes of employees. Some are not. And again, it's important to know where you stand in the at-will world. There are, of course, public policy exceptions, and I'll give you a couple of them. An employee can't be terminated if someone asks them to act unlawfully, for example, commit perjury or engage in some kind of criminal activity like price fixing. So that kind of termination is unlawful even in an at-will state. And of course, performing statutory duties such as jury duty or responding to a subpoena also protect you in your employment. So you can't be fired for going to jury duty. Acting as a whistleblower is often covered by various statutes as well, even for at-will employees. One thing I wanted to make sure that you focused on before we left this area is that there is a fundamental difference between non-renewal of a contract and termination. There's no particular reason why we would articulate to a non-renewed employee why we're not renewing them. We simply choose not to do so. Termination ends a contract, and they're fundamentally different. I've actually seen institutions sued successfully for defamation claims where they mix these two up, where they refer to somebody as being fired or terminated when they were simply not renewed. You want to be careful with that because that does have a defamatory overtone to it in some contexts. One thing that distinguishes tenured employees is that they have an expectation of continuing contracts, so they differ from the at-will pool. Collective bargaining impacts employment law quite a bit. Some of you are subject to collective bargaining rights, others are not, and that's a subspecies of special understanding in and of itself. Tenure is an unusual employment concept, typically applicable to traditional classroom faculty, and it was embraced as a concept as early as the 20th century, in the early 20th century, by AAUP, the American Association of University Professors. There was talk of unionization of faculty, but the decision was made to go a different direction, really to mimic the guilds of skilled workers in other countries at the time. What does it result in? Well, when you have tenure, you have a property interest in continued employment. And particularly at public schools, taking away that property interest requires due process. Going back to our fair and due process pathway, you might recall that a deprivation of life, liberty, or property typically requires due process. Notice and an opportunity to be heard are often common core elements of that. And typically, if you're tenured, we think that your dismissal is for cause only. So often for stated cause, and institutions are often fairly careful about articulating the types of cause dismissals that could take place for a tenured employee. Sometimes people talk about tenure as a job for life. I think we're beginning to learn that's not true, and it never was. In fact, tenure does not imply a contract for life. It's not an annuity. And in truth, the employer can terminate for cause at any time. But you keep in mind that due process is often implicated in this. Retaliation. I pick retaliation out for specific emphasis because very often in litigation, it's the retaliation claim that has the most value to a aggrieved former employee. And most of the employment statutes have either retaliation provisions and or whistleblower protections. So it goes sort of something like this, that someone has done something in the workplace and people retaliate against that individual. It could be for speech. Sometimes it is. So, for example, if I'm engaged in protected speech, which is a form of activity under number 1, that's one of the elements of a retaliation claim. I believe you fired me because I said this to the newspapers. Now, we do know that public employees speaking on matters of public importance are not always protected under the First Amendment. That's the Garcetti Doctrine. The employer must subject you to an adverse employment action, and not everything that's unpleasant is considered to be an adverse employment action. So I would say that not everything is considered retaliation. If you're concerned about this, you can talk with your human resources directors to get an idea of where those boundaries may be. And then there has to be a causal and frankly even a temporal connection between the protected activity and the so-called retaliatory and adverse employment action. So if, let's say I publish a newspaper article 10 years ago and then get fired tomorrow, the time and space relationship between those is not clear. There might not be that causal connection. What are the types of things that are involved in a protected activity? Opposition to unlawful employment practices of any kind. Participation in activities that are protected by law, such as filing a charge, testifying, assisting in an investigation or hearing. And again, notice the reference to Garcetti. There's actually a case following Garcetti that raises this very issue, where someone testified and their testimony was the basis of an adverse action. Garcetti has an exception for that, but keep in mind that some speech by employees at public institutions are not protected. When you're speaking in the course of your official duties, some courts believe that type of speech is not necessarily protected. This is something you can clarify with your institution. Employees must act in good faith, and so in order to take advantage of the protected activity, whatever activity is engaged in must be in good faith. Another way to look at this is that courts are not anxious to create employment dispute litigation out of thin air. A lot of folks are aggrieved with their bosses and co-employees. Not everything should be going to court. So we're looking for genuine attempts to exercise rights. Those are the ones that are going to be protected under employment law. Let's turn our attention to students. In the 1960s and 70s, we saw an explosion of equal protection and civil rights laws, really the foundation for multiculturalism as we think of it today. The law is sort of odd about this, so if you're not used to it, it may take a minute to accept how the law looks at this. And again, I'm not validating this, I'm simply passing along existing standards for compliance, such as I believe they exist. You may find that you have some controversy with these, and frankly, I do too at some point. So I'll try not to let that sneak in. I'll allow you to see this as it is, as opposed to as I might wish it to be, or others. Any discrimination based on race is inherently suspect. The Equal Protection Clause of the U.S. Constitution prohibits race discrimination. It's considered subject to what we call strict scrutiny. And in fact, we have specific statutes in the U.S. Code that deal with race discrimination across a variety of areas. The Civil Rights Acts of the early 1960s really instantiated some of the broadest anti-race discrimination law in American history. And in fact, the 14th Amendment gives one of the broadest powers to Congress to remediate patterns of historical race discrimination. So this one is at the top of the constitutional list. Any race discrimination has to be justified under the standard of strict scrutiny, and as you might guess, very few things pass this way. In fact, recently we just got the Fisher II opinion in a long line of race-conscious admissions cases, and there was some thought that the Supreme Court might actually say that all admission systems have to be race neutral. The Supreme Court did not say that. It is possible to use diversity as a basis for your admissions process to be race conscious. However, Fisher II clearly puts some strictures on campuses when it uses race conscious admissions. Backing up to Grutter-Gratz, we've got to use individualized assessment of each applicant, no quotas. And in some states, like Michigan, following the Chute case, which is from the United States Supreme Court, some states ban the use of race in their admissions processes, and the Supreme Court validated that practice over a very strong dissent. So race-conscious admissions survive in many parts of the United States. The message coming out of Fisher and II seems very clear to me: no quotas, and the courts will look to see, even if you are using individualized assessment, are you secretly targeting a certain number of students from a certain racial background? And if you are, they'll permit the litigation to go forward to see if that practice is occurring, and most likely strike your practice down. Sex, gender, and sexual orientation. Interestingly enough, under the U.S. Constitution, we never got an Equal Rights Amendment. We almost got it. We got some federal law that attempts to address sex discrimination, including, importantly, Title IX. But under Supreme Court thinking, sex discrimination comes under a so-called intermediate scrutiny standard, so it's somewhat less. There's no way to say this other than this, that under the Equal Protection Clause, not all discrimination is equal. Race discrimination gets strict scrutiny, whereas sex discrimination receives intermediate scrutiny. I will say that there's quite a debate in the legal community as to whether or not the new articulation of intermediate scrutiny is actually strict scrutiny sideways or in another form. I'll let you chew on that in more advanced units. But one of the famous cases was at Virginia Military Institute, which was at one time not permitting women to engage in its male adversative training programs. They were told by the court that that program did not meet the test of intermediate scrutiny, and they've since had to change practices. A couple of thoughts on race and sex discrimination. Keep in mind that these rules are from another era, the early part of the civil rights period, and probably are not as sensitive to multicultural variations or the many dimensions of sex, gender, and orientation that we think of today. Although the Department of Education has been quite progressive in its analysis of some of these issues, courts and even Congress have not always shown the same interest or ability to evolve quite as quickly. So as you get into more advanced units, you can clearly see the impact of the old dyadic world in the law on litigation and even congressional policy. What about discrimination based on class and economic standing? Interestingly enough, the court applies essentially a very low standard of scrutiny to laws that affect people based on class or economic status. Well-known authors and speakers like Richard Kahlenberg have raised this issue repeatedly, claiming the court should spend more of its time focused on class and economic division. But to date, under the Equal Protection Clause, it gets the lowest level of scrutiny. It's an interesting thing, isn't it? What about core mission delivery? Do you have a basic constitutional or statutory right to outcomes in higher education? You know, in K-12, states often promise outcomes to citizens, that you have a right to a basic education. Interestingly enough, this core mission value, which is very clear in the K-12 world, essentially disappears in higher ed. There is no clearly established constitutional or statutory right to core mission outcomes. That's caused a lot of issues for folks, especially as the cost of education has gone up, and particularly the cost to learners of education has gone up. These learner consumers now often are complaining, I'm spending a lot of money, I can't get a job, and I'm not sure what I learned. People weren't as motivated to raise these issues when it didn't cost them as much. Today, the cost of education falls so heavily on the heads of learners that they've become an empowered consumer group and have been pushing, along with banks really, for rules regarding such things as gainful employment, college scorecards, etc. If you've been paying really close attention, these issues have actually been across multiple federal administrations. So even back in the Bush administration, we saw some rumblings about accountability for core mission development and delivery. I think this is a frontier that we're likely to see quite a bit more federal compliance action. We're already seeing at the state level and through the accreditation process. The federal government has been putting more pressure through regulators on accreditors to assess outcomes, competencies, and the value of an education. Similarly, there's no generalized federal right to a safe or well learning environment. There are bits and pieces in federal law, Clery, Title IX, Safe and Drug-Free School. We considered these in another pathway, but the idea of a civil right to safety and wellness, a civil right to an outcome, is still emerging. These were rights that were not well established in the civil rights period, and then particularly with respect to safety. In many ways, we took a back step with safety in the 70s and 80s as the bystander era took root. We're working our way back from that as expectations have shifted and more people are expecting to have a reasonably safe learning environment with wellness initiatives, perhaps even more than reasonably safe. Again, I would imagine this will be a frontier of compliance work going forward. The role of accreditors and accreditation has changed. The federal government is now the direct lender, and accreditors are feeling the squeeze as the federal government is stepping in and behaving almost like a meta-accreditor. This is changing the game in Washington, and I think we're going to see significant discourse, even conflict, over the future role of accreditors and how they operate in higher education. So many of our civil rights metrics are projected onto us through Title IV funding. We talked about this earlier in other pathways, particularly due process. But congressional power now is felt throughout virtually every sector of American higher education, primarily because so many of us are taking Title IV funding directly or indirectly. And then last but hardly least on this important list, one of the most important features of all of the civil rights era was a focus on disability discrimination and combating that. It's actually quite complex in terms of the statutory scheme. There are many federal laws that impact disability. For those of us on campus, we either are dealing under Title II or 504 of the Rehabilitation Act, but there may actually be other issues as well. So this takes a certain amount of expertise to understand the panoply of disability laws that are out there. But I want you to take a step back and look at what happened in the 60s and 70s and where we are today. Out of the blue, from a period where students had no civil rights, where in the era of insularity, college was thought of as a privilege, not a right, and therefore none of these legal rights attached. Between 1960 and 1980, American college students achieved unthinkable levels of civil rights. First Amendment rights, as we had discussed in the earlier unit, a right to be free from race discrimination, sex discrimination, discrimination based on religion, freedom from discrimination based on disability. Due process started to penetrate our walls, and fair and due process ideas came through. A couple of basic rights, though, were still in transit, and we're now feeling what was left behind in the 60s and 70s period. We're talking about class, outcomes, core mission delivery, safety, and wellness. Don't these dominate the dialogue today in your compliance world? And I would expect, and I think we all know that this is coming, that as Compliance University expands, these are the areas it's likely to expand into. It might be helpful to do a quick sketch of disability law. And again, this is such a complex area that having a survival metric is really very helpful. Many folks have a handle on bits and pieces of this, but they're not quite sure how the whole dance goes together. So I thought we might step back and do a little rough justice to federal disability law. This is not always a perfect way to describe it, but it captures most of it. Let's talk about how most of the law of disability functions most of the time. This is a platform from which you can gain more deep understanding about federal disability law and how to work with it. It all begins with the opening question of whether someone is technically disabled or not. And for all intents and purposes, there's a list. You can consult with your human resources directors to try to identify this. But I say this because there are many disadvantages and differences that impact learning, some of which are considered disabilities, some are not. I'm an interesting learner because I'm convinced that I have dysgraphia. I probably have affective disorder. These are the sorts of things that when I was going to school in the 60s and 70s were not considered disabilities, and no one in their world would have thought to accommodate them, at least as I understood it. I was actually punished for my bad handwriting, and I had to figure out affective disorder issues and move from Massachusetts to Florida to start being able to function more effectively. So in one period, things might not have been recognized as disabilities. Now today they are. Some things actually come off the list, and I know in K-12 education there's been quite a bit of discussion over changes in autism spectrum issues. Again, this isn't the place to belabor that, but the reality is you're either on the list or you're off, and if you're not on the list, you're not entitled to really much of anything under most federal disability law, maybe for other reasons, but not in federal rights created by statute. Now, just because you're disabled doesn't mean you're entitled to accommodation, and there's a reason why sometimes people in higher education forget this, because we don't have the habit of always developing clear qualification standards. But in disability law, in order to claim an accommodation, you must be qualified or otherwise qualified for the program or activity in question. And there has been litigation over this. There's a very famous Supreme Court case where a nurse didn't have auditory acuity sufficient to do the job according to her superiors. She claimed she was entitled to accommodation, and the Supreme Court said that they thought under the current standards of the time that she wasn't qualified for the job, therefore didn't meet the standards necessary to ask for reasonable accommodations. It's important to recognize that people can become qualified over a period of time as technology and activities change. And so this is something of a moving target. It's not quite as bright line as I'm making it seem. But one thing has been fairly standard in Supreme Court jurisprudence interpreting the statutes is that generally we're not required to make fundamental alterations in our program or change the nature of the activity fundamentally that we're engaged in. And so if you had to alter the program fundamentally to make people qualified, you don't have to do that. And that is a barrier to people with disabilities. Again, I'm not applauding this standard necessarily, I'm simply passing it along. Now, here in higher education, we have a habit sometimes of not articulating qualification standards quite the way other businesses do. In fact, more often than not, we use so-called technical requirements, which are academic and behavioral standards. But what we often don't give students are the equivalencies of competency articulations or job qualifications. I had a student in law school who was a pilot. He said, this is a very interesting program because I learned how to fly, And when I learned how to fly, they taught me how to take the aircraft off the ground and land it safely. But in this program, all you do is show me crashes and tell me not to do that. And he said, I really am not entirely sure what it is I'm supposed to learn other than avoid the negative. Sometimes, particularly with our students with disabilities, we find that we don't intervene with them until they act out and violate behavioral standards or fail to meet our minimum academic standards. And yet, we have to ask ourselves, are these individuals qualified for the program? Well, if we don't have other qualification standards other than our technical requirements, then they essentially are presumed to be qualified for the program, even if they're not. I want to put up a little word of warning right now. There's been some rumbling from the Justice Department and OCR that suggests to some of us that sooner or later OCR or Justice and Ed may begin to think that it's discriminatory in higher education not to articulate qualification standards. And you might have noticed that accrediting bodies are putting a lot more emphasis now on articulated competencies, outcomes, and assessments. Putting the pieces together, this is a backdoor way of beginning to create a new world order around disability law in higher education. Or to put it another way, for years, we didn't articulate qualification standards typically the way other businesses did. We relied on our technical requirements, which are a proxy for qualification standards. That may not persist. So here we are in Compliance 101, anticipating the possibility of significant change in higher education law potentially down the road. If you are qualified or otherwise qualified and disabled, you're generally entitled to reasonable accommodation. Notice that this changes between K-12 and higher ed. In the K-12 system, accommodation guarantees outcomes. In higher ed, it only guarantees equality of opportunity. And many families and students are not prepared for this transition. They don't recognize the very significant legal change that occurs between the K-12 system and higher ed. And as a result, a lot of people fall in the cracks. This is something that's an avoidable issue, a trap that we can work on with our education power. What's reasonable is often subject to debate, and we've been noticing particularly recently with comfort and service animals that our idea of what might be reasonable about the menagerie of animals coming to our residence facilities might be a little different from what the federal government is thinking. It never hurts to look at what's happening in employment law or in K-12 to get a signal for what might end up being reasonable here. Again, these are not the same environments, and you may get different results, but it does signal certain trends. And for example, the comfort and service issue has been common in K-12 for some time, and a lot of the understanding about the need and the appropriateness of comfort and service animals comes from that universe. Now, might have heard some debate about this, and in fact, this has been in transit the last few years, so-called direct threat analysis. So let's assume someone is disabled, they're qualified, you've given them a reasonable accommodation, but they now present a direct threat. Disability law typically allows you to disassociate someone from a program if they present a direct threat. Of course, they may also be in violation of your behavioral standards or other standards, but they might not be, and you could ask them to leave because of that. The debate that seems to be brewing right now has been over whether or not direct threat analysis requires threats to others or one can simply pose a threat to oneself. There's actually been a very interesting 2016 Justice Department resolution that speaks to some of these issues, and although this isn't really the place to develop that, I think it really requires an intermediate to advanced unit to do so. Let me at least signal to you that one of the not surprising things the government has said is the quality of your qualification standards matters a lot if you're going to use direct threat analysis with individuals who present harm to themselves. Again, notice the intersectionality with accreditation. You may not be picking this up, obviously, from what you're working on right now, but I want you to see this, that through the back door of accreditation, the Department of Ed in particular is beginning to force higher ed to do more competencies, outcomes, and assessment work, which connects very closely with qualification standards. We're heading down this pathway, And I think the Department of Ed and the Department of Justice may be concerned that we are allowing people to come to our programs and persist in them until they fail or act out, when in fact it is either known or knowable that they really weren't qualified for the program all along. Compliance with disability law is very complex. You do need special training. This is not an area for amateurs, and one of the most basic mistakes that people make is they think they can figure out reasonable accommodations on their own. You really want to be intersecting with the professionals on your campus. And in my experience, people sometimes are not in congruence with the accommodation experts. They're not agreeing with those individuals. But when it comes down to compliance with this area of the law, a significant amount of deference to the experts on your campus is appropriate and necessary. Accommodations change from K to 12 to higher ed. IEPs, individual education plans, are common in K to 12. We tend not to do that in higher ed, or at least call it that. And folks that are moving from one learning environment to another often really struggle making the transposition, hence the retention issues that many folks with disabilities still face in higher ed. Typically in higher ed, we look for students to self-identify before accommodations are made. And therefore, we need to think of ways to facilitate self-disclosure. Typically in the admissions process, we stay away from asking or even opening the door for the sharing of information about disabilities, for fear perhaps that we might discriminate against people or be perceived doing so. It sends an implicit message is that we'd rather not know, even if that's not the message that people are receiving. And then a lot of folks come to college and they come with an attitude which probably works against them, thinking they're better off to start fresh without all of the baggage that may have followed them through the K-12 system. Better off not to know. Well, my experience is we typically are much better off knowing as opposed to not knowing. We're going to have to break that cultural barrier to the extent it exists. And then let's keep in mind that today disability law is defining disabilities quite broadly, and it's an ever-evolving metric. In fact, to me, I've gotten to the point where I don't really see disabilities anymore. I see differences. I came from an era where people were abled or disabled, and frankly, as a child, I think the way I was raised was to see disabilities almost in a negative light, that's something to be avoided or to feel sorry about. But today, I think very differently about that. I think we all have differences, and they're to be celebrated, and I think the modern learning experience really can be built around celebrating our learning differences, maximizing the potential of who we are. I just don't see it quite the way I used to. Keep in mind, again, that students must be qualified or otherwise qualified. I can't hammer this enough. I think this is the frontier of disability law, and thinking about qualification standards is probably the next step. Don't have to fundamentally alter a program. Individual assessment. We see this in admissions, Grutter and Gratz. If you're going to run race-conscious admissions, you've got to do individual assessment. If you're going to do disability work, you've got to do individual assessment. This is a common theme or meme throughout compliance law, is treat our students as individuals. Don't aggregate them into groups, herd them up, treat everybody the same. Each learner is unique. Disability law in higher ed does not guarantee success, just equal opportunity. You can enforce your technical requirements. Disabled students are entitled to due process, and one of the mistakes that some schools have made, and I can show you OCR resolution agreements to back this up, is you can't make the rules up as you go along. We call that Calvin ball. Remember that old Calvin and Hobbes cartoon when Calvin and Hobbes would make the rules of the game up as they were playing it? That's a big no-no, and disabled students are entitled to basic due process as employees are as well. You can intervene with people with a direct threat, and new thinking from the Department of Justice, which isn't that new to me, but it will appear to some, and the Department of Ed, is that we can intervene on direct threat basis for both self-harming and harm to others. But there are standards to do that, and they have to be meticulously followed. Hint, hint, individual assessment and qualification articulation are a big part of it.